carrying on then, number 2 for our laws and regulations compliance. First of all then, what do we do when we think, or when we do actually find non-compliance? Well, first of all needs to be documented. Okay, so as an auditor, we need to document the findings to make sure that we've got sufficient and appropriate evidence all written down. Then we will discuss the matter with management to find out what their viewpoint is. We will probably also discuss with their lawyer as well, and that will be the lawyer of the management and our own. Okay, then we will consider the impact on other areas. So consider the impact on the audit, because what we're thinking here is, again, do we need to create provisions, or could it be more than that? Could it be actually the management have lied about this, and so therefore have they lied about other things as well? So we have to consider the impact on all the other areas, not just the things like provisions and disclosures. Okay, so you're really looking at as well, can we now rely on other management representations? So on other things that management have said. Okay, so they're the 5 things that we have to go through once we find out that there's been some non-compliance and we found it out ourselves. Okay, so reporting duties. First of all, we should tell directors immediately, as soon as we find it, because it's breaking the law. So this should happen without delay and make the reports. Okay, who are we going to make reports to? Those charged with governance. Okay, we make a report to those charged with governance. We communicate to the audit committee. And we consider legal advice, which we've got there with talking about our lawyers. What about the shareholders? Okay, shareholders only if it causes the financial statements to not give a true and fair view. Only if accounts are now not true and fair, or a fundamental uncertainty has arisen. Okay, and that would just be through the normal audit reports. Regulatory authorities, so the actual authorities where the compliance has been broken, the auditor has to decide if there's a responsibility or not. And obviously legal advice and ethical advice might be needed here. Okay, so we tell directors immediately, we report to those charged with governance, we communicate it to the audit committee. We don't tell shareholders, it comes to the audit report itself, and it's our decision whether to report it to the authorities. Now, when do we actually withdraw from the engagement? Because I see this a lot in the exams. People say, and then we leave them as a client. Well, we don't. That's, to withdraw from the engagement is the last resort. We are a business. We want to keep our clients as long as possible, okay? But what would make us do it then? What are the things to think about? First of all, are the management, are they implicated? Is it their fault? Did they know about it? If they did, then maybe we do need to withdraw because we can't rely on anything they've said. Did it affect the relationship between us and the client? Or was it just a small matter that they missed out on and we can carry on? If it's affected the relationship too much, we have to withdraw. Maybe we have a legal responsibility to withdraw. Obviously, if we do, then that's it. We have to. But we would consider all alternatives. And of course, if management refuse to remedy the situation, then we need to withdraw. If the management, if we're not sure about their integrity, we need to withdraw. Okay. And when withdrawing, what we must do, we must discuss it with management. So if we do it, discuss reasons with the management. So this is if we do withdraw, discuss the reasons with the management and consider any legal requirements that we might have to report to shareholders, etc. as to why. Okay, so learn those. I know they're not very sexy things to learn, but get on top of it and you're there. That is everything to do with laws and regulations compliance. So again, try exams and make sure your knowledge is up to date.